Hello everyone, welcome to Jamaica 411. Thank you so much for stopping by, keeping me company as usual. If you're here with me for the first time, welcome. Please remember to subscribe, give the video a thumbs up, share, and feel free to leave your comments in the comments section. To my subscribers, welcome back. Always nice to have you. Always. Of course, you know the ropes. You're going to go ahead and give the video a thumbs up from now on. You're going to share, rejoin me. And of course, you know you're going to leave your comments as usual. And of course, you know also I thank you in advance. So now that you have rejoined me, let's get down to business. Yes. So in this video now, we are going to resume our reading of Justice Althea Jarrett's judgment in the Andrew Holness versus the Integrity Commission, you can call it that. That is to do with his statutory declarations not being certified and them threatening not to certify it until the FID, the Financial Investigation Division, completes their investigation into the companies and the movement of money from one company to the next. I don't know why that is suspicious, but it seems suspicious to them. And so that looked like another 2 or 3 years. So Mass Holness decides, now wait so long. He is going to avail himself of his right under the law, which is to take the matter for judicial review if he feels himself aggrieved. And he obviously feels himself aggrieved. So now they're at the stage in the application for a judicial review where he seeks to have permission. You have to have permission to go forward. But in order to go forward, he has to give them enough arguments. He has to lay out his reasons for wanting to go to judicial review. And that can only be because a judicial review is only granted in circumstances where a public officer or body, such as the Integrity Commission, made a decision or did something that the citizen or another company, I suppose, may feel that they were not acting according to law. That's the only time you can seek to have a judicial review. What the court will do in a judicial review is to quash the order if they determine that the order was illegal, the procedure was unfair, or the procedure that they followed was not the procedure that was given to them by law. So everything has to do with the law that the commission is acting under, and that will be the Integrity Commission Act and the Corruption Prevention Act. Those two acts. So they have to follow the law. If they don't, then it means now that the court can throw it out. And the form of throwing out that the court will do is to quash the decision that they made. The court will not give them instruction, but by the decision of the court, they will act according to the advice of the court, what the court says should have happened. So we have covered 19 paragraphs in the judgment so far. And the last of what we did was to go through the 28 remedies that Andrew Holness is seeking from the judicial review. And now we are going to continue at 20. So if you have not yet watched the other 2 videos that I did on this reading of the judgment, you might want to check them out first and then return here, or you can take a chance that you'll be able to follow along as I read. But if you take my recommendations, the first video that I did on this ruling of the court, it is called the ruling, paragraphs 1 to 14. And then, of course, the second video is entitled The 28 Remedies Sought by Andrew Holness, and that reading was for paragraphs 15 to 19. So now that I've given you all the background, I am going to continue our reading, and I'll try and see how far we can get in this particular video. So we resume our reading at paragraph 20. And it says there are 69 grounds in the application. The grounds, of course, would be related now to the remedies sought. In other words, Holness is asking for 28 remedies, and now he's setting out the grounds by which he hoped that the court would accept his argument and allow the judicial review. So Justice Jarrett went on to say, I do not intend to reproduce all of them verbatim in this judgment, but will provide the following summary. They have been categorized by the applicants under the following heads. That means heading A, breach of natural justice and procedural fairness, in that the process of the investigation conducted by the second respondent investigator was procedurally unfair and breached the applicant's right to a fair hearing at common law and under Section 16(2) of the Constitution. B. Constitutional breaches, in that Section 14(5) of the Corruption Prevention Act breaches the right to life, liberty, and security of the person enshrined in Section 13(3)(a) of the Constitution. Section 14(5) of the Corruption Prevention Act is unconstitutional as it breaches the due process guarantees under Section 16(2) of the Constitution. The disclosure that the applicants are the subject of an investigation and or reporting to the Financial Investigation Division breached their rights to privacy under Sections 13(3)(j)(2) and 13(3)(j)(3) of the Constitution. The respondents breached the applicants' right to equality before the law, guaranteed by Section 13(3)(g) of the Constitution, and the right under Section 13(3)(h) of the Constitution to equitable and humane treatment by a public authority in the course of any function. C. Irrationality and unreasonableness, in that the findings, conclusions, and recommendations made in the reports were unfair, unreasonable, and irrational. Under this head are also grounds which allege that 1. There was a breach of the Prime Minister's legitimate expectation that the investigation into his 2021 statutory declaration would be conducted independently, impartially, fairly, and in the public interest. 2. Based on the true construction of Section 14(5) of the Corruption Prevention Act, the Prime Minister would be provided with the wealth element and would be given the background to the alleged irregularities being investigated. 3. The respondents acted ultra vires illegally and abused their power and discretion in that they prepared a report for tabling in Parliament with extraneous matters. And just so you know, ultra vires mean they're acting outside of the powers that the law gave them. 4. The tabling was in breach of Section 54 of the Integrity Commission Act. 5. The respondents failed to perform their statutory duty. 6. The referral of the August 30, 2024 report to the Financial Investigation Division and Tax Administration, Jamaica, circumvents the statutory procedure. And then there is 7, the Director of Investigation, having not made a finding of corruption, failed to recommend to the Integrity Commission that the Prime Minister be publicly exonerated. Yeah, my peeps, this one look a little sticky though, because, it was the Prime Minister who refused to submit his personal expenses that caused the investigation to stall. So I'm not too sure about this one. 8. The tabling of the August 30, 2024 report was intended to embarrass and cause harm to the applicants. 9. The DI illegally assumed jurisdiction over the Prime Minister's 2022 and 2023 statutory declarations, given that the allegation of disproportionate assets to lawful income was limited to December 31, 2021. Let me pause here briefly because this is very interesting. You recall that in the report, the investigator's report, the commission had referred the matter to him for him to look into the 2021 statutory declaration for what they thought at the time was unexplained increases in his assets to the tune of 4.4 million. You remember that? Then we don't hear no gunfire about that. And the next thing we know, he's looking into the 2022 declaration, which the Director of Information and Complaints said he had not examined up to that point. So the question is, how did the investigator get his hands on it? How did he get his hands on the 2022 and 2023 declaration when Holness had in writing a letter from the Director of Information and Complaints that he did not examine the two, and yet the investigator had it and had them investigating for, according to him, illicit enrichment. And so this now is what they are talking about. Yes, my peeps. For that, look like trouble there to me. I don't know. What do you think? Let me continue. 10. The Director of Investigation and the Integrity Commission improperly lifted the corporate veil and improperly failed to give the Prime Minister an opportunity to provide an explanation for the alleged disproportionate asset or net worth of $1,930,000. So these are the arguments that Andrew Holness will be, or his attorneys will be seeking to present to the judicial review, but you have to pass this stage. And what I find most fascinating, more than one thing fascinating about this passage in the grounds for seeking this judicial review, is where it said, this is what Holness said now, that he was never told what the figure was that was disproportionate to his lawful income. How can that be? They forgot to tell him that this is 1.9 million. You need to explain, because remember what it is, it's unexplained increase. So if it is unexplained, you need an explanation. One would think that among your investigation, the first thing you should do is ask, how come? What's this about? And let him go find it. If the wealth is unexplained to you, then the man who submitted the statutory declaration in the first place, is him supposed to come and explain to you where this 1.93 million come from? That not sound like common sense, my peeps? Then Andrew Holness would have gone and looked and said, okay, this is where it is, or that is where it is. And then the investigation would have been over, one way or another, because if him can't show you what the source is for this 1.9 million, then you can go ahead and prosecute him for illicit enrichment. What the hell is this? The everlasting digging into accounts and a look on this, and every minute am I write to the man, I ask the man about this and ask the man about that. What is the source of this income? What is the source of that income? Find out about the 1.93 million first. But that's not what they did, my peeps. They never did that at all. Them start to rummage in the man's business and then fail to ask him the critical question. We found $1.9 million that we believe is unexplained wealth. We can't see where this wealth was generated. Can you please explain? Let him go find it. Let him go find it, my peeps. Tell me if you agree with me or you disagree with me now. But this, for me, is the most incredible thing about this investigation. But let me continue. At paragraph 21, Milady went on to say, with respect to the special report, you remember that special report is the one that was tabled in the House, and it was in that report that the IC now, the Commission, recommended to Parliament that they refer the report to the FID for further investigations, and that unless the FID completes that investigation that they are requesting, those statutory declarations will not be certified. And then the face the argument, I'm not going with it, right? So, of course, it's now under review, and that looked to me like it under some serious trouble, but I will leave Your Honor to tell us all about it. So, let's go again. With respect to the special report, there are grounds which contend that the statement in that report, and I'm quoting from the report now, there can be no finality to the matter until the Financial Investigation Division has completed its work, end of quote, is contrary to the statutory regime of the Integrity Commission Act and is therefore ultra vires. I remember ultra vires means, right? Outside of what the law permits. And illegal, of course, if the law does not permit it or give you specific instructions as to that, then it must be illegal. The further statement that there can be, and I'm a quote from the special report again, no certification of a statutory declaration until the Commission's Director of Information and Complaints is satisfied that the statutory declaration has been duly completed. End of quote. And the judge is reading on, is based upon an unlawful foundation as it presumes that the Director of Information and Complaints satisfaction is based on the work of the FID, and there is no statutory basis for this. Next heading, the evidence in support of the application. Yes, you have to have evidence if you're going to say that the IC did something that is not correct, didn't follow the correct procedure, acted ultra vires outside of their powers. You have to show evidence of all of this. Every line item must have the evidence to back up so the judge can see and make a decision. So at 22, Milady went on to say, the evidence in support of the application is that of the Prime Minister contained in an affidavit filed by him on September 30, 2024, and a further affidavit filed on October 17, 2024. The latter, which is the October one, the latter affidavit merely exhibits copies of entire documents which were only partially exhibited in the first affidavit. The report dated August 30, 2024, and the special report dated September 5, 2024, are both exhibited to the Prime Minister's first affidavit, an affidavit of Vahine Headlam, filed on November 7, 2024, exhibits an addendum to the August 30, 2024 report dated September 9, 2024. The addendum only includes a witness statement received from a third party after the October 30, 2024 report was tabled in Parliament. You remember when that one was tabled? After they tabled the report for the investigator, and then the special report and the indicative ruling. Those went in on the same day, but there was another submission to the Parliament which was tabled. It was the witness statement by one of I believe it was NCB. Yes, I do think so. And the statement came in late, so they tabled it after. So now at last we come to the report dated August 30, 2024. Which report was that, you'll ask? That's the investigator's report, Mr. Kevon Stevenson. So we're going to read now what Milady has to say about that. Now this is at 23. The Director of Investigation made several findings and conclusions in the August 30, 2024 report. The following is an abstract of some of them. A. The Prime Minister filed statutory declarations for the periods in question but failed to include in them 4 bank accounts jointly held by him, contrary to the Integrity Commission Act and the Parliament Integrity of Members Act. B. The Prime Minister has or had financial interest in 3 companies. One is Imperium, one is Positive Media Solution Limited, and Estate Bridge Limited. He has sole ownership of Imperium and retains control over its finances. C. Based on the analysis of the information available with respect to the Prime Minister personally, there was a negative net worth for the period 2021, but the Director of Investigation did not have his personal expenses over the relevant period to determine whether there was illicit enrichment based on the source and application method, as the Prime Minister did not provide a schedule of his personal expenses. On the analysis done, there does not appear to be any unexplained growth in net worth for 2021. Very interesting. That, you will recall, was the subject of the referral from the commission to the Director of Investigation when they asked him to look into that 4.4 million that they believed was unexplained growth in his assets. And as the judge is pointing out, when it comes to Andrew Holness himself, there was a negative. So, as she said, there does not appear to be any unexplained growth in net worth for 2021. The referral was specifically that he should look into it for 2021 period. Good. Let's go on. At D, combining the Prime Minister's assets and liabilities with those of the companies he is associated with was warranted because it was impossible to distinguish the Prime Minister's assets and liabilities from those of these companies. How could he have said that? How could he have said that? Because the Prime Minister's assets that are in the company's name, you will have the stocks and bonds would be in the company's name, not his name. Then the property at Shenstone would have the company listed as the owner. So how can he say that there is no way him can distinguish, or it's difficult to distinguish between the two? Up to now, I still not get it, but this is what she said is in the report. Let us continue. E says, on combining the Prime Minister's assets and liabilities with those of the companies he is associated with, the Director of Investigation found what appeared to be unexplained growth in the Prime Minister's net worth of just over $1.9 million for which year? 2022. On the evidence available to the Director of Investigation, including explanations provided, the increase observed in the Prime Minister's asset or net worth cannot be justified without more by his known income and liabilities. However, the Director of Investigation was hindered in his attempts to resolve this issue due to the Prime Minister's refusal to provide a breakdown of his expenses for the period under investigation. The Director of Investigation, therefore, is not able to determine what portion of the Prime Minister's income was used for living expenses and not available for asset acquisition. At F, before the Director of Investigation can make the final conclusion on the question of illicit enrichment, the use of funds by Positive Jamaica to partly purchase a bond worth $94,000 and the operation of companies with which the Prime Minister is or was associated and which he named as his source of funds to acquire particular assets would need to be resolved by the relevant entities. Significant financial transactions of over 473 million Jamaican dollars and withdrawals of over 427 million Jamaican dollars were seen among three of the reference companies: Imperium, Positive Media, and Estate Bridge Limited, between 2020 and June 2023. Only 61,000 US dollars was funded by the Prime Minister to purchase bond of $94,000 US. The remaining amount of $32,000 US was apparently taken from funds belonging to a registered charity, Positive Jamaica Foundation Limited, of which the Prime Minister was at the material time a director. Questions therefore arise as to whether the Prime Minister's alleged use of funds from Positive Jamaica Foundation Limited to purchase a personal asset amount to misappropriation. Then H, the Prime Minister's indication on July 16, 2024, that the full portion of the bond, $94,000, was erroneously attributed to him, is misleading and unsupported by the evidence. I states the funding of Positive Media, in which Imperium was a majority shareholder before being replaced in 2022 by the Prime Minister's sons, raises concerns about the true nature of the company. This is based on the Prime Minister's explanation that Positive Media is funded by Imperium. But the evidence obtained by the Director of Investigation suggests that it is Positive Media which is funding Imperium. Over 70 million was transferred from Positive Media to Imperium, and over 50 million from Imperium to Positive Media during the relevant period. At J, Imperium, Positive Media, and Estate Bridge Limited filed nil tax returns for 2021 and 2022 when these companies reported income and other business activities in their audited financial statements. This raises tax compliance concerns. The question is whether these companies had any income and expenses over the relevant period which were not disclosed in their returns to the Tax Administration Jamaica. So at 24, we come now to what the judge refers to as summarized below are some of the recommendations made by the DI. So we'll reach the recommendations now. A, the report. B, referred to the Director of Corruption Prosecution for consideration whether the offense of making a false statement in a statutory declaration and or whether any other offenses have been committed. That's the first one. Next, a copy of the report be referred to the Commissioner General, Tax Administration Jamaica, in relation to the nil income tax returns of Imperium, Positive Media, Estate Bridge, and Green Emerald Limited. That's the second one. Third, at C, a copy of the report be sent to the FID for necessary investigation to be conducted, given questions surrounding the funding and operations of Positive Media, Positive Jamaica Foundation Limited, and Green Emerald Limited. The findings of the investigation raise significant questions around these companies' income generating capacity relative to the funds which have been identified in their accounts. The Director of Investigation's powers, limited resources, and exigencies relating to remit and time do not allow for sufficient ventilation of this issue. That's his reason why I'm saying it need to go to the FID. Them had the money it look like, and them had the time to do the further investigations that they believe is required. So he made 3 referrals, and what we're going to do, we're going to leave it here for now while we look back at what we covered today. First, we started with the 69 grounds in the application. Then we had the evidence in support of the application for judicial review. Next, we took a look at the investigator's report, at his findings and conclusions. And finally, we looked at his recommendations. This is the investigator now. So what we'll do tomorrow now, we'll pick up at the part where the court now examines the special report. That report that was tabled in the Parliament, where the IC was asking the Parliament to refer the investigation report to the FID. That's the one we'll be looking at tomorrow at paragraph 25. This is our third segment, and we'll return tomorrow with more for you. So we're going to take a long break now. We're going to get a bite to eat. We're going to get some sleep, and then we'll return tomorrow. So I want to thank you for joining me. Yes, for sharing, liking, subscribing, as well as leaving your comments. So until next time, you take very good care of yourselves and walk good.